Allow me to thank the organizers for this wonderful event. I hope I will meet your expectations, and I promise I'll be easy. I do only one case, I will not use Latin words, and I'll be on time. I'll be on time. Okay, so this case is about 4 years and 10 months, or if I'm right, it's about 58 months. Mr. Andrle, a Czech citizen, has to serve, has to fulfill, and we should see the same circumstances. So, what is the Czech respective legislation about? Women, and only women, are preferred if they take care of children. If Mr. Andrle, he was divorced, he took care of 2 of his children, raised them up, did the upbringing. He claimed to be rewarded the same diminished year, but he was not successful. So we are speaking about right to property. Mr. Andrle had to did additional 4 years of insured periods, and he was unsuccessful. And let me remind once again, it's not a Slovak regulation. It's not about child labor. It's not about birth. It's about taking care of children. Under Czech regulation, if we speak about standard circumstances, it's about 10 years. And only women. We will see the context, because this case has been, let's say, interpretation done by insurance carrier was upheld by Czech Constitutional Court, and oddly enough, it was supported by our European Court of Human Rights as well. So we have to see the context. That's our first part. The second, of course, and I have to be fair, there was one crucial point done by European Court, and that was that, you see, there is something in the history, but Czechs are willing to do something with it. And we did, but in waves, and the last wave renewed, let's say, the positive discrimination of women. And I'm not against women. I can be here because my wife took care of my 2 children, so I'm not against. So please don't obtain oppression. I'm against these things, but we have to see how the, let's say, assessment procedure or argumentation done on constitutional and European level works. So the last point done on my side is we will never be equal, this time not because of the letter of law, but this time because of our practice, because we fear European courts. So to be brief, and of course I'm slightly running out of time, so we have to see that it's fault of the communism era. Communists, they did the bad thing. Why? They did it in 1956. What happened in 1956? We have friends from Poland, in Poznań, revolts. Hungary, yeah, but you see, Poznań, if I'm not mistaken, in October, in Hungary in November, and our law, November 1956, because you really don't want to have revolts in Czechoslovakia. We have to see it in the historical context. But at that time, you have to understand the second thing. We classified and scaled all trades and occupations, and according to their purpose or importance for society or for the Communistic Party. So we have all trades were classified into 3 categories, and those who were doing the first category, both men and women, they were awarded the same retirement age as women in 3rd category. So at that time, there were two sets of rules. Let's say minimum age, retirement age for women, plus those who did merits, who performed trades important for the state and society, they could have the same retirement age. We can go more into depth, but let's say this. In 1995, the state decided, or the legislator decided, we have to abolish the old employment classification, because we can't say that certain occupations are important, more important than others. Oddly enough, we did the same in 2023. So once again, we have employment categories, but only for 3 occupations. Minors were so successful, they have never agreed to leave employment categories. So speaking about minors, they have always had the same preferred retirement ages and calculation formulas. And of course, minors were only men. And of 2023, we have firefighters because of COVID-19, and health workers, or let's say medics, paramedics, and so on and so forth. So we open these books once again. What the legislator decided not to abolish were these preferred or diminished ages for women, and from the beginning, from 60s, they were reclassified, and we had several categories of diminished ages, and their amount depended on a number of children women were able to raise up. I will not play with other numbers, but just to see the trend, there were certain waves back and forth, but seen, let's say, in last 30 years, the legislator decided to increase retirement ages or retirement age. So far, everybody who was born in 1971 and onwards is 65. Retirement age is 65. No deductions for children. The same retirement age. So the government keep the word. You can find it in a European case, Andrle. The court judges said, look, Czechs are doing something, and that's true. But it will be effective after 13 years. So the first generation, the first cohort of insureds coming, they have 65, is coming in 2036. And now look out. Up to 2036, we have this preferential formula for women. Only women, if they take care of children, their retirement age is diminished. Plus, there is reform. I will come back to the previous slide. Plus, there was a reform of 2022, and in this reform, there is additional layer of preferences. The government decided they will enact something what can be called upbringings allowance. This upbringing allowance can be paid and should be paid to the parent who took care most. What is the problem with Czech scheme? We don't have investigation procedures. According to our, let's say, 80-year tradition, the parent who took care most is a woman, and it's per definition. Why? Because there is no investigation procedure. There is birth certificate. And if there is a birth certificate, it's deemed that the woman took care 10 years. That's how does it works. And now you have 2022, effective as of 2023. And we have two cohorts of insureds persons. Those who already are given retirement pensions or old age pensions. Speaking about this category, only women will be paid this upbringing allowance. For example, my mother. My father doesn't have a chance. That is the past. But the past goes up to 2036. And now we have the future. What about the future? The problem is about the future that if a man is requiring, I was the parent who took care most, there is no procedure to prove. Of course, we have standard procedure codes. Administrative agencies can do it, but they have never done it because it was always from 60s of previous century. It was always presumed that the woman is the person who took care most. So there is a problem that, of course, there is not informal structure. We don't have officials to do it in higher numbers. So that is, let's say, the context. So let's coming back to the pedigree. Let's see legal arguments. Speaking about Czech Constitutional Court, I will use words employed by the judge, Mrs. Wagnerová. She was against that judgment. She was a judge, and she said it's a fishy. You say that this regulation is good, but what you did as the court, you mentioned that it's objective, it's non-arbitrary, and it's reasonable, but we don't explain it because it was done in arguments of parties. So in this case, in Czech version, you will not find, I'm speaking about the Constitutional Court case, you will not find any arguments. There is just one line. It's non-arbitrary, it's objective, and it's, of course, our tradition. And the arguments are given in papers of parties. When we go to the European level, when we go to Mr. Andrle case, and we see, now just for repetition, Mr. Andrle is divorced, two children in his custody. He did 10 years, and he is claiming his retirement age around 57. His age 57. He was unsuccessful, and he was given old age pension at 61 of his age. And the reason was, you are not a woman. And what the European Court of Human Rights did, it states it's historic event. You started with this in 60s or 50s of previous century. And of course, and it has to be clarified and added once again, of course, the totalitarian regime wanted to appease population. But at the same time, there was a vision of, let's say, social or socialistic or communistic woman who, at least in Czechoslovakia, at the same time took care of children and was full-time employed. So Doppelbelastung, or as they say, family, private, and business life, difficult. And we have up to date, we have statistic data, and we are not changing that 98% of all, let's say, parents who take care of children are only women. So we have to be fair and say that, of course, and it's seen in Mr. Andrle case as well, that there are only few men who took care of their children, mostly because the mother died, or she was exiled during the communism, or children were kidnapped, or, I don't know, divorced, and children were put into the custody of the father. So there are very rare cases, but there are rare cases. And the Czech Constitutional Court stated we can't do nothing. We can abolish, we can quash the legislation, but it wouldn't help women, nor women nor men. Therefore, we don't do it. Speaking about the European Court, let's say the rational or the holding was it's your tradition, you are going to change it, we understand that you need time, we will give you time and you will change it. The problem is, look at 2023, it's here and it will be here for at least for up to 2036, and from 2036 we can start having cases like parents arguing who was the prevailing caretaker. So I think we will have, let's say in 40s of this century, we will have another Andrle 2 case, but for conclusion, because I'm almost done, for conclusion, simply speaking about the majority of the population still, it's Andrle case goes right to the heart of our, let's say, family patterns or welfare state model. It's so the caretaker, not only for children, but also for elderly, are women, and always have been, and probably always will be. Therefore, it's just that they are preferred. The problem is that the scheme, the law is not able, not even with the help of European authorities, is not able to prepare any sort of test or, let's say, argumentation that would help those minorities who replaced women because women died or they were divorced and so on and so forth. So speaking about this, the picture of majority was preferred, and hopefully we will have to go back to Mr. Andrle's second case, because now we can't say it's our tradition and it's connected with communism. We simply created new tradition, and to be honest, this tradition is connected with application. We don't put it into the law because we know that that would annoy European authorities. We have it in our application. Thank you for your attention.